Our next case is Kendzierski versus Macomb County. Kendzierski et al. Versus Macomb County.
May it please the Court. My name is Susan Zitterman. I'm here on behalf of the County of Macomb. I would like to reserve 2 minutes of my time for rebuttal.
That's fine.
The county today asks that this court issue a decision on its application, reversing the Court of Appeals, and holding that basic contract principles must be correctly applied to this case that is, at its core, a simple breach of contract action. Upon application of those principles to the language of the collective bargaining agreements at issue, the conclusion is clear, we would submit, that there is no ambiguity as to lifetime vesting that warrants resort to extrinsic evidence outside of the four corners of the collective bargaining agreements. That being said, the county again wishes to make clear, as it has throughout this appeal, that notwithstanding the legal vesting question, the county fully intends to continue health care benefits to its retirees as confirmed by the extrinsic evidence in this case. That being said, however, the county must remain free, consistent with the provisions of the collective bargaining agreement, to change those benefits in the future as the need arises. It must not be bound, as the Court of Appeals has held in this case, to provide a specific plan of insurance from a specific carrier with specific co-pays and specific prescription drug deductibles and such. We would ask that the court then reverse the Court of Appeals on that issue and hold that there is no vesting in this case. As I turn to address some of these principles of contract interpretation that I believe compel this conclusion, I would welcome questions from the court if you have any.
Counsel, how does this apply to the fact that we're dealing with the public sector and not a private corporation?
I think that is a distinction that has no relevance, Your Honor. I believe we must turn to basic contract principles.
Where does it, even if I look at Reese, why? Where does it say it? The cases that were recently decided by the Supreme Court are quite clear in the fact that these were private companies. There's no mention whatsoever about public sector unions or public sector negotiations.
That is correct. What the court did, though, is apply basic contract principles, and those principles should apply whether there is a public corporation or a municipality involved or public unions under para.
But wouldn't they, if they had wanted this to apply to the public sector, wouldn't they have inserted that? If we're going to follow, I mean, the whole argument is a strict constructionalist argument, and distinctions are commonly made between private corporations and the public sector. So why in this case should I read into the language something that isn't there?
I believe that that's what the plaintiffs are asking the court to do, is to read something into the language of the contract that is not there.
But aren't you asking to? Because you're asking me to you're asking me to insert the public sector. Basically, you're asking me to insert the same standard for public sector that you would for private entities or private corporations, and there's no mention to the distinguishing components between a public sector negotiation and that of a private corporation. And wouldn't it be fair to say that the two are distinctly different and have always been different?
I don't believe so, Your Honor, not with respect to the question of interpreting a contract. The contracts in this case, they have a durational clause. They run for 3 or 4 years. They have an entire agreement clause. Why would we ignore the plain language of the contract because of policies outside of the contract? I do not believe that there are reasoned principles that allow us to do so. There are certainly practical concerns that would govern negotiations, and people would want to negotiate different terms in a contract.
Counsel,
That is-
you argued that people shouldn't be in fear of losing their health benefits, but if this court were to hold that this is not in fact vested, is there anything to preclude the county from taking away all health benefits if it so chooses to?
Other than its moral commitment and the commitment it's made to the electorate, the people that elect the county officials, there is no contractual requirement that they vest in these retirees, the benefits under this contract for the rest of their lives.
So, but the point being, though, that if this court were to hold under your interpretation, ultimately, because it wasn't vested under your argument, the county could strip all benefits if it so chooses to, and there would be nothing to prevent that from happening legally. Is that correct?
Under the contract, I believe that to be the case. But as has happened in every contract that's been negotiated every 3-year period since the 1980s, the benefits will be provided. The county has gone to great extents to get a bond passed to ensure it is fiscally able to do so. What this case does, though, is ties the county to a specific insurance contract, and that is not consistent with the language of the contract that it entered into.
Has the level of retiree health benefits changed over time?
Yes, Your Honor. There have been there's been 2 types of changes to the benefits. One, negotiated through the contracts. For example, the co-pays changed, the spousal coverage changed, but there's also benefits that are provided outside of the contracts, hearing, health. All of these things are given by the county to its retirees. So we have a history of changing benefits. We negotiated just before the contract at issue. We went from Blue Cross traditional to Blue Cross PPO. The issue in this case is that during the contract period, they changed from PPO 6 to PPO 5, I believe, or 5 to 6. So there have been changes to benefits as time goes on in this case.
Counsel, why would you have a provision for a survivor benefit if this was only going to be a 3-year negotiation? I mean, is it fair to say, or could one argue that the inclusion of a survivor benefit would take this beyond a 3-year period? Because why would you have a 3-year, ultimately a survivor benefit for a retiree? Isn't that somewhat implicit that you're looking at a duration because we're dealing with retirees?
I believe not, because the death of the employee and the transition to coverage for the survivor alone can occur during the 3-year period. There is no reason it cannot occur. An employee may retire at the beginning of the contract, become eligible for retiree health care benefits, and then pass away during that 3-year period. The fact that it can also occur outside of the contract period does not answer the question. The question is answered by the durational clause in the contract.
But the question is, if you have a durational clause and then you have a survivor benefit, isn't it fair to say that that isn't quite silence? According to the Supreme Court, wouldn't it be fair to say that one could read in that isn't silent on that? Because the survivor benefit when you're dealing with retirees is the idea that this is going to be for a long duration of time. For retirees, because of the fact that we're dealing with the demographic that we're dealing with, doesn't the survivor benefit open this up to not being silent, but rather to being something significant, that this is a long-term plan? Again,
the survivor benefit in this case does not run for the survivor's lifetime, as it did in some of the federal court cases. The contract here just says when the employee dies, the survivor has benefits, just like when a retiree retires, the retiree has benefits. There's no suggestion of duration beyond the end of the contract because it can happen during the course of the contract. Now, we've renegotiated.
And I hear what you're saying. I hear what you're saying. I totally hear what you're saying. The thing that I'm going to, in terms of according to the U.S. Supreme Court, is the idea that we have to look to whether it's silent or not. And I guess the question that I would kind of pose back to you is it your argument that when dealing with retirees, which is what we're dealing with, that a 3-year durational period, when you're dealing with a survivor benefit, would meet industry standards, because ultimately you're talking about retirees. You're not talking about people who are looking for new work, are looking for new jobs. You're talking about people when the understanding of the contract and the terms of the conditions of the contract isn't silent if you put a survivor benefit in, which would naturally use kind of a deductive reasoning skill, which would not be silent according to Rees. And the idea being that you're saying that you're dealing with retirees. You're dealing with people who are older. You're dealing with people who are not working. You're dealing with people who are not looking for new work or going to be able to find new work. So isn't it fair to say that ultimately dealing with the silence question, that isn't really quite silent because of this? Or are we going to go back to, you're going to say that this is 3 years and it doesn't matter that it's retirees or older people, and that industry standard wouldn't really be applicable to the common sense approach that when you're dealing with retirees and a survivor benefit would look for someone to look beyond the 3-year duration to more of an extended time period, which is how retirees would understand this?
I think all the concerns that you're expressing are probably the same concerns that existed in the Sixth Circuit and created the presumption that that the silence that I believe is in the contract creates an inference of intent to investing because we care for our retirees. I would submit that those inferences are not appropriate, and that we should, regardless of the extra contractual concerns for our retirees and desire that they are taken care of once they retire, that we are still bound by the terms of the contract and the durational clause.
Counsel, I read the Court of Appeals opinion to have misunderstood or misused the term latent ambiguity. When I read the opinion, it seems like they are pointing to what they view as ambiguity within the four corners of the contract, which I understand to be patent ambiguity, not latent ambiguity. Do you agree with that?
Yes, absolutely, Your Honor.
Okay.
I believe that was the argument that misspoke or miscited. That they did find ambiguity in the three provisions: the spousal support, the having to pick up Medicare benefits at age 65, and the
and maybe the most I think the one they lead with is that the agreements all, I understand there are a number of agreements, but they all include the phrase that the county will provide fully paid health care to retirees who receive county pension. And I assume you don't believe the pension to be up for grabs every 3 years.
Oh no, the pension is totally separate. It's governed by an ordinance that is. No,
I understand.
Yes.
I've assumed you agreed with me about that. And if you do, then do you think the language in the contract that says the county will provide fully paid health care to retirees who receive county pension creates some tension with the durational clause? Or?
I do not, because
Okay.
it too is governed until the end of this agreement. Thank you. I'll reserve the rest of my time unless the court has any questions.
How many collective bargaining agreements are at issue in this case?
I believe there's 23, approximately.
And they all contain similar provisions?
Yes, yes. I don't think there's any dispute as to the nature of the provisions in this case.
Okay. Thank you, counsel.
Thank you.
Thank you, counsel.
Good morning, Your Honors. Christopher Leggio on behalf of plaintiff retirees. I want to start by saying we're here also to ask the court see that basic contract principles are applied. Where we differ with the county is that we have a broader definition of that. Our definition of basic contract principles includes an examination of the contract on its plain meaning, what the contract language says, but its explicit terms, but also contract interpretation that requires a review of patent and latent ambiguity. And that's where we differ with the county. And that's where we think the Court of Appeals may have misused the latent and patent ambiguity, but found with the contract that there was ambiguity in the contract, citing the contract provisions in terms of survivor benefits, the snapback benefits for a retiree who retires, goes to work someplace else, gets health care. They would lose their health care while employed. After their post-retirement employment ends, county insurance snaps back. The ability to be paid cash in lieu of health care also can snap back. And the Court of Appeals found that those items were suggested ambiguity and found that that these items, that the health care was vested and unalterable without consent. That language that also appears in the contract. And Your Honor, I don't believe there's only 30 contracts. There were 30 bargaining units. There's many, many more contracts than the 30. There's 30 bargaining units, but more contracts than that because there's multiple contracts per bargaining unit. What the county's argument amounts to is that...
Are they, not to interrupt, but are they materially similar? Or are
they are materially similar. All contain, with consent of the parties, changes, unalterable changes unless with the consent of the parties. And they have the substantial equivalence language. What the county is really arguing, it seems to us, is this, that there is no ambiguity unless the contracts recite magic words. That unless the provisions in this collective bargaining agreement with regard to retiree health care use the word vested or lifetime, unless those magic words appear, then there is no ambiguity and the general duration clause applies. And we submit to you that that is inconsistent with ordinary contract principles of construction. We submit to you it's also inconsistent with Tackett and the Supreme Court case in Reese. Both of those cases specifically say that you can determine contract provisions through explicit language, implied language, and resort to custom and practice in the industry.
So what's your best, give us your best argument for where the ambiguity is within the four corners of the contract. I think the Court of Appeals actually did an examination of the ambiguity within the contract, so I think they just mislabeled their work. But why isn't counsel correct that the clues the Court of Appeals pointed to are all relevant within a 3-year period? So where is the ambiguity with the durational clause?
Well, Your Honor, I would say to you that the notion that all of those provisions were going to be all realized in a 3-year contract defies mother wit. It defies common sense. Survivorship is, in other words, what they are suggesting is this, that you should read the contract this way, that a retiree, when they retire, regardless of when they retire, let's imagine for this scenario, they retire 2 weeks before the contract expires. They get health care benefits by contract for 2 weeks, and their surviving spouse will get it only if I die, the participant dies, and she gets a pension during those 2 weeks. The notion that this was what was intended by that contract language, as I say, defies common sense. And I think what the court found is these provisions here in the contract suggest a duration date that exceeds the 3 years of the contract. And because of that, the court looked at extrinsic evidence as the ordinary principles of contract construction require.
Before you get to the extrinsic evidence, what is your position with respect to when the health care benefits vested? In other words, did they vest at some point before the last batch of collective bargaining agreements, or is it this last batch, is that when they vested? Because it appears there have been changes over the years, right? Well,
yes, and let me speak to that. The changes that have occurred, let me narrow this. The changes to retiree health care benefits, the county has cited 8 changes. 6 of those were health care benefit improvements. The 2 other changes are not a decrease in benefits. There has been collectively bargained negotiated benefits, and to the extent that those collectively bargained negotiated benefits apply, they apply to the batch of people who retire under that contract. So if I retire under a contract 10 years ago, my retiree health care benefits are defined in that contract. The people who retire after me, if this county...
Is it your position that they vested for your clients when they retired? I thought that your position changed to they vested at the level established in the most recent collective bargaining agreements. Am I wrong?
Yeah, that's not our position, Your Honor.
Your position is as of when they retired?
Yes, Your Honor.
Let me ask this question. So is it? Am I supposed to look then to when each member of the plaintiff class retired to see whether those collective bargaining agreements contain these same 3 provisions that the Court of Appeals focused on, and I think you're focusing on today?
Well,
or do I look at the most recent batch?
No, you don't look at the most recent, Your Honor, because the most recent collective bargaining, this is not a floating benefit. My benefits that I got at the day I retired don't float. If I retired in 2001, my benefits aren't floating with the future contracts that are negotiated after I retire. That's not what we're proposing. That's what we've never argued that position, Your Honor. What you look at is the collective bargaining agreements, and for the ease of the examination, the courts, the trial court and the Court of Appeals looked at exemplar contracts, contracts that in effect represented the contracts as...
But I guess I'm getting a little confused now. First there were 23, now there's 30 or more than 30, but those are all the most recent ones, or you're talking about those are all the ones throughout the last 35 or 40 years?
Your Honor,
we have a lot more, right?
We are suing on contracts that cover the period 1989 through 2010, and they cover all the collective bargaining agreements, all the collective bargaining units involved. So there are multiple contracts. And I want to make sure I don't leave you with any confusion. We are not suggesting that the retirees' benefits are floating from contract to contract. Our argument here is that the contracts represent and promise to these retirees that the health care you have before you retire will be the health care you'll have in retirement, subject to substantial equivalence and subject to changes with the party's consent. Now, my
but then
point...
again, I would need to look at the 1983 collective bargaining agreement to see what the level of benefits you're claiming vested at that time as to whoever retired while that contract was in effect. Is that your position?
That would be the examination, Your Honor, but I think it's not quite as burdensome as you might be suggesting.
I'm not worried about the burden. I just trying to make sure. I mean, it could be hundreds of contracts. I just want to make sure I understand the undertaking. I'm not the level of work.
Okay, I'm not suggesting that. Yes, Your Honor. The answer to that is yes. The court, once it found ambiguity, then followed the ordinary rules of contract construction that this court has followed since 1849, and in 2010 this court reiterated that those are the principles. You look at extrinsic evidence, and here the extrinsic evidence, before we begin the inventory of it, I want to emphasize the fact that the Court of Appeals found that the extrinsic evidence was unrefuted and undisputed and unrebutted. So what is that extrinsic evidence?
Before we get to the extrinsic, I'm sorry, I'm slowing you down.
Oh, that's okay.
Before we get to the extrinsic evidence, help me with how do I understand the test for patent ambiguity? Does it have to be the contract is equally susceptible to two interpretations? Can it be, does it have to be 50-50? It can be 75-25? Can it be 90-10?
I've never seen a case that used the percentages, but they do use the phrase equally susceptible to two reasonable interpretations for patent ambiguity.
Okay.
And we would submit here.
That's the test we use for ambiguity within the language of a statute. I just wondered if it's exactly the same for within a contract.
I didn't catch the first part.
I understand equally susceptible to be the test we've used for language within a statute. But my question was, is the test, do you believe the test would be exactly the same when we're applying it to a contract?
Reasonably susceptible to two interpretations, two reasonable interpretations.
Reasonable.
Plausible interpretations. So the court, after it reviewed the contract language that challenges the notion that the general durational clause applies, looked at the extrinsic evidence, and this evidence was considerable. The court found the county admissions persuasive. These county admissions were made by officers of the county, from the executive to the county, to financial directors, to corporation councils, all of those admissions. And some of them made under oath in Act 312 arbitrations, in contract negotiations, during representations to retirees as they are about to depart from their employment to their retirement. Use words like lifetime, vested, contractual obligation, paid for, IOU, promises to the retirees. The county set up a trust fund dedicated, but long before Act 202, long before the state statute required any kind of remedies, they set up a trust fund. The trust fund was set up to finance entirely retiree health care obligations. They went to the state treasurer in this state and represented to them that they needed to sell bonds for the dedicated purpose of retiree health care benefits. And they told investors that is what this money was to be used for. Now, this is not the behavior of an entity that thinks it has an obligation that runs for 3 years, and every 3 years it can determine whether it will continue health care benefits. The fact of the matter is, and let me say this parenthetically, this issue about the great intentions of the county and their high moral obligation, I'm not impugning any of that. But the reality is here, as everybody knows, that at times of economic distress, big ticket items are looked at, and to suggest that the county may not again severely cut or even indeed eliminate retiree health care benefits is a walk past the graveyard. It's whistling past the graveyard. These retirees work for these benefits. They gave labor for these benefits. And in exchange for that, they thought they had this promise that was not simply tied to some moral duty, lofty moral duty that the county now says it's obligated to follow. But the county's behavior, these admissions, is the behavior of an entity that believes that it has a contract obligation. Think about it for a moment. The finance director in an Act 312 arbitration under oath told the arbitrator, who was discharging his duties under that act, that they could not give raises to public safety police officers because they had to finance the retiree health care. And that individual said, an obligation is an obligation. So it was good for the county to claim they had contractual restrictions when they were trying to avoid pay raises for police officers. And now when the retirees seek to enforce those contractual rights, they claim it's never been a contract, or it's a contract that only runs 3 years, and it's up to us whether we're going to honor it. These retirees did not render the work they performed on the if-come promise that the county would have good grace and always provide them with health care benefits. The other point I would make about that is this. These benefits, there is no evidence in the record that the county ever went and got an agreement or consent from the parties that were going to be impacted by this. They completely suggest that that's nothing to be considered. It evaporates every 3 years. It doesn't exist anymore. That was there as a protection for these retirees. It was an acknowledgement that health care may have to change in the future because the world is it's fluid. But it was not an idea that you'd only have to, every 3 years you could be consulted, and after that you had no right to be consulted about devastating changes in your retiree health care benefits. And finally, I want to say this. Your Honor spoke about common sense and the law making sense. Does anyone believe that people work their entire lives and had language in collective bargaining agreements about survivorship benefits and snapback benefits and the right to be paid cash and then to be snapback health care? And they did that thinking that their retiree health care benefits was only protected for 3 years? The obligation this court has is to divine the intent of the parties, and you do that through applying basic contract principles. And the basic contract principle here that the county wants you to not pay attention to is latent ambiguity. Nothing in Tackett, nothing in Reese suggests otherwise. Indeed, both of those cases say you look at implicit, what can be implied from the contract. What's the practice and custom in the industry? And the county wants you to disregard that, and they want you to disregard the things that are said by the county officials that not just gesture to the obligation of lifetime retiree health care benefits, but nail it down, confirm it. Thank you.
Thank you, Mr. Leggio. Thank you very much. I think you've got a few minutes remaining.
If the court does look to extrinsic evidence, there is an issue of fact as to what was intended. The extrinsic or the evidence shows that the contracts changed from 3-year period to 3-year period, the provisions that the retirees obtain. We would submit, however, that there is no need to look to, it is not permissible to look to extrinsic evidence in this case, and that we rely on the language of the contract. And then the only issue remaining probably for the lower courts is whether there was a breach of that contract by the changes that were made. So, does the court have any additional questions?
Okay, thank you very much, Ms. Zitterman.
Thank you, Your Honor.
Case will be submitted.